Hello everyone, welcome to Company 360. Today I'm going to share some recent news. So let's start with the video. TVS Motor Company secures patent registration. The Intellectual Property Appellate Board (IPAP) directed the Controller of Patents and Designs to grant a patent to TVS Motor Company Limited for an invention related to anti-roll bar, which helps in improving bending stiffness and enhances the safety and stability of vehicle without transferring shock forces to the chassis. Previously, the respondent passed an order refusing grant of the patent on the grounds of lack of novelty when compared with cited prior art. While passing the order, the IPAP concluded that the cited prior art, though related to anti-roll bar only, has differential features when compared with the invention of the appellant, thereby making the appellant's invention distinguishable. Therefore, the cited prior art is similar but not an identical document. Moreover, the IPAP held that a prior art is considered as anticipatory if all the features of the invention under examination are present in the cited prior art document. In the present case, the same was held to be not true. Accordingly, the IPAP set aside the refusal order of the respondent and directed the respondent to grant the patent after filing of the amended claim sets by the appellant as directed by the IPAP. Now let's have a look at news related to trademarks. First case, Stimulif versus Stimulit. Bombay High Court mules infringing similarity between two registered marks. Franco-Indian Pharmaceuticals Private Limited, who is the plaintiff in this case, filed an infringement suit against Corona Remedies Private Limited, who is the defendant, for unauthorized passing off of the patent's mark Stimulif by open advertisement of the registered trademark Stimulit by the defendant. The counsel for defendant argued that the products of the parties are different, as the one sold by the defendant is an allopathic preparation for the treatment of breast cancer or infertility, while the plaintiff's formulation is Ayurvedic used as liver supplement. Additionally, while relying on Section 28 Clause 3 of the Trademarks Act 1999, the defendant argued when there are two registered proprietors of trademark which are identical, neither party shall have the exclusive right to use their mark against the other. The Bombay High Court applied two distinct approaches while assessing the deceptive similarity. One with respect to the common perception upon seeing the marks, and second based on the defendant's conduct. On the first account, the court noted that because of the niche segregation in goods of the parties, even the slightest amount of confusion shall not be permitted. On the second account, the court noted that the moment the defendant sought the registration of the mark Stimulit, there was an implicit acceptance that the mark as a whole is distinctive and capable of being distinguished. Therefore, the defendant could not have argued that the word stimule is common to the trade. Resultantly, the court observed that the two marks are deceptively similar. The court observed that when there is a conflict between two registered proprietors, the evolution of rights in common law was essential to enable the court to determine whose rights were better and superior. In view of the same, the court noted that the registration and the use of the plaintiff's mark is greater by at least 2 decades, coupled with the fact that his sales are incomparably higher than that of the defendant. Thus, an injunction order was issued against the defendant for usage in the mark Stimulit. Ex parte interim injunction issued against the mark Cinephos. While issuing an ad interim injunction against the use of the mark Cinephos, the Bombay High Court observed that Cinephos Systems, who is the defendant in this case, attempted to pass off the trademark of Cinephos, who is the plaintiff, as a whole, and also illicitly put to use the plaintiff's label on which it has copyright protection. The plaintiff has been using the mark Cinephos since 1947 for audiovisual equipment including projectors, screens, etc., which was subsequently registered in 1979 under Class 9 for cinematographic hardware products. Peculiarly, the plaintiff used to carry on its business from a rented premise till 1992 post which the landlord let the premise out to the defendant. Thereafter, the defendant began to advertise his goods basis the plaintiff's billboard over the same premise. The court observed that the plaintiff had previously filed opposition and rectification proceedings against the marks of the defendant, and hence the defendant not only had constructive but actual notice of the plaintiff's prior registration. The court issued an ex parte ad interim injunction against the defendant, restraining them from advertising the mark Cinephos in any manner. Next news is related to the Himalaya Drug Company, who secured a win for IP protection. The Himalaya Drug Company and others, who is the plaintiff in this case, filed a suit before the High Court of Delhi, seeking injunction against the infringement by Ashok Kumar and others, who are the defendant. The defendant was involved in infringement of 150 registered trademarks of Himalaya across multiple class and 82 domain names of the plaintiff. Since 1930, the plaintiff had registered rights in the trademark for medicinal, Ayurvedic and pharmaceutical preparations. The plaintiff claimed that the logo constituted original artistic work under the Copyright Act 1957. The plaintiff further extended that the defendant is conducting fraudulent activities by offering business opportunities and distributorship of the plaintiff's products through its rogue website like www.himalayapharmacy.in. Despite operating over 7 websites, the court noted that the exact identity of the defendant could not be ascertained. Notably, the plaint also contained information regarding emails, pamphlets, franchise application forms, fraudulent franchisee agreements, product lists, etc. of the defendant using the logo of the plaintiff. The court further observed that the total investment sought by the defendant on its website for franchising ranges from 10 lakh to 20 lakh Indian rupees. Surprisingly, each of the fraudulent distributorship agreement executed by the defendant was signed by Mr. Philippe Hayden, who was the retired Chief Executive Officer of the plaintiff, that is, Himalaya. Accordingly, the court was of the opinion that the defendant illegally sought to capitalize the goodwill of the plaintiff without any due authorization, and further issued an ad interim injunction restraining the defendant from using the impugned trademarks or the domain names of the plaintiff in any manner. The court also ordered the banks of the defendant to not allow any withdrawals from their accounts or safes except with the leave of the court. That's all for this video. To know about such trendy topics, stay tuned to the channel. Thank you and have a nice day ahead.